Okay, welcome back. This video will deal with cross-examination and rules of evidence, and we'll see if we have some time at the end. I might even throw in closing arguments. If not, we'll save the closing arguments, also known as closing statements, for another video. Okay, so let's get going in terms of cross-examination. What is the purpose? This we know happens after an attorney for the other side has completed their direct examination of their witness. Then you have an opportunity to cross-examine their witness. So the purpose is to show the judge and the jury that a witness should not be believed because of one of the following reasons. One is either the witness can't remember the facts. They can't remember what they said in a deposition or in a police report. Number two, they did not give all of the facts in direct examination. They shouldn't be believed because they are lying by omission, right? They might have left out some really important details in their answers to those direct examination questions. Number three, they told a different story at some other time. So either during a deposition or when they were interviewed by the police. Maybe they had a totally different story at the scene of the crime or when the crime actually occurred, compared to the story that they're telling now. Number four, maybe this witness has a reputation for lying, so maybe they shouldn't be trusted because they kind of are known to be a liar. Number five, they have a special relationship to one of the parties, so they maybe shouldn't be trusted because there's a conflict of interest that they may or may not have disclosed. It might be up to you to bring out that conflict of interest during cross-examination. Or six, maybe this witness shouldn't be believed because they bear a grudge towards one of the parties. Maybe there was some history there, and that they're testifying against this person out of revenge or out of spite, right? So when we take a look at what the objective of cross-examination is, it's to make the other side's their witnesses less believable in the eyes of the trier of fact. So for our purposes, that's the jury. So the whole purpose of cross-examination is to make that witness for the other side look less trustworthy, less believable. So we might try to attempt to establish that the witness is lying, attempt to show that they're prejudiced against, our defendant, let's say, or our witness. We might attempt to show that their testimony is improbable or impossible, right? We might get us to admit certain prejudicial facts. We might get them to say that they don't like the defendant. We might say, you and the defendant, you and my client, you go back quite a ways, don't you? And you say, yeah. What was your relationship like? Maybe well, it's off and on. Did you guys fight a lot? Yeah. So it's fair to say that you don't like my client very much, do you? No, I don't. Right? So that could be a line of questioning to kind of bring out these prejudicial facts from the witness on cross-examination. Also, we could try to show that the witness gave questionable opinions because of their inability to to see or to hear, and that doesn't have to necessarily be a disability, but maybe it was just really dark outside. There was no light. So how could they possibly have seen anything? Maybe they were listening to music with their headphones on. So that might call into question what they claimed that they had heard. So we might also want to show the incompetence of an expert witness. So if we have an expert on the stand giving direct testimony in cross-examination, this is when you want to try to question their qualifications or question their competence. And we might also, as another objective, attempt to uncover any contradictory statements. So we kind of want the witness to contradict themselves. That's the easy way to make you seem less credible on the witness stand. So some suggestions for cross-examination: don't give the witness the opportunity to re-emphasize the strong points made during direct examination. So as soon as they start to reiterate, once they start to repeat or re-emphasize any of this powerful testimony that they gave during direct, just make sure to cut them off. And there's various ways that we can cut off a witness. You could ask them, sir, please answer my question, or that's not what I asked you, whatever it takes basically to get them to change the topic, right? You don't want to use cross-examination to further solidify the effect of direct examination. Another suggestion is never try to allow the witness to explain anything. So if they're starting to get into an explanation that you don't want them to talk about, you could simply say, thank you, you answered my question, right? When you do cross-examination, you'll see that the line of questioning is quite different. We tend to use yes or no type of questions. So we use leading questions on cross-examination. You never want to use open-ended questions because you don't know what that witness is going to say on the stand. So if you ask a yes or no type of question, you say, so you don't like my client very much, do you? And they say, no, but, and you say, thank you, you answered my question, and then move on to the next question, right? Don't let them try to explain anything. They said, no, they don't like your client, that's it, right? So we want to try to limit our questions to yes or no type of answers as much as possible. Also, this is your opportunity to lead the witness. Essentially, you get to control what is said. So you could lead the witness kind of where you want them to go through these types of yes or no lines of questioning, and that you do should impeach the witness or prove the issues of your case. So when we talk about impeach the witness, it means to show that they're not credible, or that they can't be trusted. So those are your questions for cross-examination. Should do one of those two things: either prove the issues of your case, of your story, or show that this witness's testimony can't be trusted. Okay, so we'll see an example of some cross-examination going on. Wait for this video to start.
Mr. Hightower, you had a .45 caliber gun in your hand the night Chris Alexander was murdered.
Yes.
It was in your hand and you were looking at the Alexander home.
Mm-hmm.
You didn't see anyone outside when you looked out the door.
No, I didn't.
You did not see a car in the driveway.
No.
You did not hear the screeching of tires.
No.
But you had a .45 caliber gun in your hand.
Yes, I did.
And that gun was your weapon.
Yes.
And it's loaded with .45 caliber ammunition.
Yes.
Were you aware that .45 caliber ammunition was dug out of the floor of the Alexander home?
No, not to now.
Okay. Were you aware that the weapon that killed Mr. Alexander was a .45 caliber weapon?
No, not to now.
Not till now. Of course, your weapon's never been tested.
Correct.
Well, your brother is the chief of police.
Yes, he is.
And your brother came to talk to you that night.
Him and along with other detectives.
Yeah, Detective Morris wasn't there, though.
No.
You gave a statement later about what happened.
No, I gave a statement then.
Your brother was the first cop you talked to about this.
Mm-hmm.
And we can agree that you called your brother after the shot was fired.
Yes.
Now, you don't like Chris Alexander very much, do you?
Not really.
I mean, he's involved in drugs.
Mm-hmm.
A bad person to have living across the street from your family,
Yes.
from your wife,
Mm-hmm.
from your kids.
Yes.
A threat to the neighborhood, huh?
Big threat to the neighborhood.
Big threat. Well, he's not a threat anymore, is he, Mr. Hightower?
No, not the best of my knowledge.
Well,
No.
he's dead now, and
Yes, he is.
now you have had your own issues with the law in the past, haven't you?
Yes, I have.
You have actually lied to the federal government about money before, haven't you?
No, I haven't lied. I just didn't record a $10,000. Yes, it wasn't a lie.
Well, you know, when you tell the federal government on your income taxes how much money you've made, that's a sworn promise, right?
Yes, it is.
And you made a promise that was not accurate,
Correct.
and that was for your benefit. You didn't have to pay taxes on that $10,000,
Right.
although eventually it caught up with you.
Yes, it did.
And once it caught up with you, you paid it off.
Yes, not a problem.
But that was a time when you were not honest to someone.
Correct.
You've also had drug issues in the past yourself.
No, I had drug issues with my brother.
You have drug issues with your brother.
Yes.
So your brother's drug issues became a problem in your life?
Yes, it did.
And your brother has really never recovered from having these drug problems.
Right.
And Mr. Alexander, according to your testimony, was one of his sources for his drugs.
Yes.
He won't be selling your brother drugs anymore, will he?
No, not to the best of my knowledge.
Not to the best of your knowledge. And I would imagine that that you know.
Yes.
I mean, you were awake that night,
Yes, I woke up from the gunshot.
and you had the gun in your hand,
Yes.
and he was across the street from you.
Yes.
And by your own testimony, nobody else was there at that time.
Nobody that I know of.
Now, Mr. Hightower, would it surprise you to learn that your phone number is on the records showing that you called Mr. Alexander the night that he was murdered?
No, my brother was over to my house that night.
Well, your cell phone shows up on his cell phone record, showing that you called him. Was it your testimony here today that you've never called Chris Alexander?
No, I didn't.
Someone else, if that's the case, then someone else must have used your phone.
Yes.
But you didn't make that call.
No, I didn't make that call.
You didn't make that call. Referring opposing counsel to Defense Exhibit Echo, a copy of a 3-page incident report filed in January of the year that Mr. Alexander was murdered. Now, sir, you told us previously that you live on Lullaby Lane,
Yes, I do.
across the street from the Alexanders.
Yes, I do.
All right, very good. Now, you have called the police department before about drug activity in your neighborhood.
Yes, I have.
In fact, you called the police department about drug activity in your neighborhood in January.
Yes.
And when you called the police department in January, they sent someone out to your house.
Yes, they did.
And the individual that they sent out to your house was a Mr. Willie Alexander.
Right.
Mr. Alexander took your statement about what had happened.
Mm-hmm.
And he took your information
Yes.
to make certain that they would be able to get in touch with you if they found anything else, right?
Correct.
Now, a review of those records indicate that your home phone number is 727-555-3461. Is that in fact your home phone number?
Yes, it is.
It is. All right, sir. Now, did you know that the phone records of Mr. Alexander's cell phone have been gotten to show the phone activity that day, the day he was murdered?
No, I didn't know that, but
I imagine you didn't know that. Is that somewhat surprising to you?
somewhat. Yes.
Somewhat, yes. Now, sir, just out of curiosity, referring opposing counsel to what's been previously marked as defense exhibit golf for identification. Your Honor, may I approach the witness? Now, you said your number is 3461. Let's take a look at this exhibit of the phone numbers who called Mr. Alexander, and just look up at me when you find your home phone number there. You find it, sir?
Yes, it did.
And are you able to read the time at which that phone call was made from your phone?
Yes.
And that was in the afternoon of the day that Mr. Alexander was murdered. Was that a yes?
Yes, it is.
All right, and if I might have that, and you agree that that is your phone number on that record?
Yes, it is.
Now, you told us you heard yelling at the Alexander home that afternoon.
Yeah, earlier that day.
Earlier that day. Mm-hmm. And you'll agree with me that around 4:30 in the afternoon is earlier in the day from the time that Mr. Alexander was murdered.
I really don't know what time he was murdered, but
if the record seems to show to us that it happened around the time of the gunshot, would that surprise you?
Yeah, I mean, no, that wouldn't surprise me because when I heard the gunshot, it's when I woke up.
Okay. But there was yelling involving Mr. Alexander earlier in the day.
Yes, it was.
But you couldn't make out who else was yelling.
No, I didn't. No, I couldn't at that time. No.
But someone used your phone to call him that very afternoon.
As I told you earlier, my brother was there. Ricky was there earlier. He had left till like 8:30.
So you hang out a lot with Ricky, Mr. Hightower?
No, I don't hang out with my brother, but I do try to stay in contact with him to see if he's okay.
Now, sir, Ricky's been a problem for you, hasn't he?
Ricky has been a big problem for my whole family.
I'm sure he has.
Okay,
Referring opposing counsel, what's been...
You could watch the whole thing if you'd like, but I think that gives a pretty good idea of what a good cross-examination would look like. So lots of yes or no type of questions, lots of leading the witness. And clearly, those questions were designed to try to make it look like the witness is the one who killed this guy, this drug dealer guy, right? So there was also the attempt to discredit the witness by bringing up his past legal problems and basically lying on a tax return. So we see all of the say objectives and a lot of the suggestions for cross-examination being used pretty effectively there. Okay, so moving on to rules of evidence. So the rules of evidence basically just establish what is and what is not admissible as evidence. So they're used to regulate the admission of proof. This could be either oral evidence, verbal evidence in form of testimony, or physical evidence, such as DNA or hair samples or a murder weapon or drugs or whatever it might be. The rules of evidence are designed to ensure that both parties receive a fair hearing, and to exclude any evidence that's deemed irrelevant or incompetent or untrustworthy or unduly prejudicial. So they're designed to have a level playing field. If it appears that a rule of evidence is being violated, an attorney may raise an objection to the judge. The judge will then decide whether the rules have been violated, and that's when a judge will say sustain or overrule, right? So if a judge says overruled, that means it's the judge's opinion that there hasn't been a violation of the rules of evidence, and the objection is overruled. Proceed with the line of questioning. If the judge says sustained, that means he or she believes that there was a violation of the rules of evidence, and the line of questioning needs to stop, or needs to change direction. When it comes to direct examination and say rules of evidence, we spoke a little bit about this before in the previous video, but witnesses may not be asked leading questions during direct examination. So you can't ask something like, you were not in the building that day, were you? Or you can't say, Mr. Hayes, isn't it true that you dislike Darryl Bryant? Right? You can't ask these types of leading yes or no types of questions. You have to ask open-ended questions. Also, witnesses can't give long narrative type of answers. They can't go on a tangent. They have to give succinct, short, clear, to the point answers to your questions. Also, evidence about the character of a witness or a defendant might not be introduced, so you can't have character evidence unless that person's character is a major issue pertaining to the case. So if we're dealing with an online scammer, you might be able to use some character evidence to show that this person has a history of lying and cheating. But if it doesn't have anything directly to do with the case, then you can't bring in somebody's past sexual history or their past gambling addiction or something, unless it's somehow relevant to the case at hand. You are allowed to help your witness remember something that they said earlier. So it's okay to help them along, or to refer them to the trial transcript or to a specific point in a document that they might be looking at. When it comes to cross-examination, you should ask leading questions when you're cross-examining your opponent's witness, and you're not limited to say just the information that was mentioned in direct examination. So cross-examination may include topics that weren't covered in direct examination. And as part of cross-examination, as we've said, you may want to show that the witness is not reliable, right? That they shouldn't be believed. This is what we mean when we talk about impeaching a witness. Is that we're showing that they're not believable. We shouldn't trust what they're saying here. When it comes to hearsay is any out-of-court statement that is offered to prove the truth of the contents of the statement. We basically can think of hearsay as something I heard from someone else, right? someone else told me this. Okay, well, that's hearsay, right? That's not admissible. Get the person who told you that to come on the stand and testify. So, hearsay is generally not admissible. A judge can make exceptions, but it would be rare. It would be a tight rope that you would be walking, or a fine line that a judge would be walking in terms of admitting hearsay testimony. So it's generally not acceptable in court. When it comes to impeachment, so impeaching a witness, it can be done by asking the witnesses questions about prior bad conduct that shows that the witness shouldn't be believed, right? So prior criminal records, perhaps. So prior criminal convictions. You could also ask about prior statements made by the witness that contradict his or her testimony at the trial. Also, you can ask them questions about the bias or prejudice of the witness. So the witness may have reason to favor or disfavor one side of the case. Maybe they really don't like the defendant, or maybe they're related to the prosecution, one of the prosecuting attorneys somehow. Who knows, right? These are all ways that you can try to impeach the witness. Also, you could ask questions about the accuracy of his or her sensory perceptions. So, I'll try to find clips from My Cousin Vinny. If you haven't seen the movie, it's actually a really good, a good portrayal of a trial. It's comedy and it's a movie, so there's some suspension of reality in there. But a big part of, say, impeaching the witnesses in that case, is questioning whether they could have possibly seen what they are claiming to have seen. And in some cases, it's because of a person's eyesight. In other cases, it's because of all the obstructions that would have been in the way between this person and the event that they are claiming to have seen. Okay, so how do we introduce physical evidence into court? How do we get it into the case? Well, here's a couple steps that you would follow. You would first, let's just say you wanna submit this pen into evidence here. You would say, Your Honor, I ask that this pen be marked for identification as Plaintiff's Exhibit 1, and then after the presiding judge marks it, ask for permission to approach the witness, right? So you would say, Your Honor, I'd like to have this marked as Plaintiff's Exhibit 1. Your Honor, may I approach the witness? You go ahead and approach the witness. Well, you ask for permission, then you go to your opposing attorney, right, with your pen. It says here a letter, but we're going to stick with this pen. You go to the opposing attorney, show it to the opposing attorney, and they say, you cool with this, right? So you show the pen to the opposing attorney. They say, yep, that's legit. You would then go to the witness who you're questioning, and you would say, in this case, Mr. King, do you recognize this pen, which is marked Plaintiff's Exhibit 1 for identification? The witness then explains what it is. You'd say, yeah, I recognize it. That's Bobby's pen from work, right? So you would say to the judge, Your Honor, I offer this pen marked Plaintiff's Exhibit 1 for identification into evidence. So you're basically offering the pen to the judge for them to inspect. So I would like to offer this, or offer this pen into evidence. After the opposing counsel has had an opportunity to object, they might say, "Objection, Your Honor." Irrelevant, right? Like, what the hell does that pen have to do with anything that we're talking about? So this is an opportunity for your opposing side to object to that item being entered into evidence. If there is such an objection, the judge will rule on whether or not that pen might be admitted into evidence. So basically go through this little ritual every time you want to introduce a physical piece of evidence into or a physical object into evidence. It has to be done through a witness. So if this were a knife, you might ask the officer who found the knife at the crime scene and who bagged the knife at the crime scene. You might ask them, what is this thing, right? They'll tell you what it is, and go through this spiel. You say, "Your Honor, I would like to submit this into evidence." So just make sure that when you're submitting physical evidence into the case, or physical objects into the evidence, that you have a witness that you can do that through, right? So make sure you plan ahead for that when preparing for questioning your witnesses. When it comes to objections, we'll have a handout, and maybe I'll do a little video, or maybe I'll find a video about some of the more common objections that are made. So some of the ones that happen most frequently. But objections can be made whenever an attorney or a witness has violated the rules of evidence. So the objection should be made as soon as the improper question is asked by the other attorney, and before the witness has the opportunity to answer. So this is why when the opposing side is questioning their witness, or even cross-examining your witness, it's very important that you're paying attention to what is being said, because you might want to know that information for cross-examination or for redirect. But also you're looking for potential violations of the rules of evidence that you can object to. So the judge will ask the objecting attorney the reason. So why are you objecting? Typically, depends. Somebody might say, "Objection, Your Honor," and then the judge might say, "What is your reason for objecting?" And they might respond by saying, "Leading the witness," or sometimes the attorney might just say, "Objection, Your Honor, leading the witness," right? It kind of just depends on the judge, depends on the culture of that courtroom, let's say. So the judge may allow a response from the objecting attorney, and basically the judge is saying, "Okay, leading the witness," and the person who is doing the questioning, the judge can ask them what they think. Why are you asking these questions? Is this relevant somehow? And based upon that response, the judge might sustain the objection, or might overrule the objection. If it's sustained, then that line of questioning ends. or you have to rephrase the question in some way, whatever the case may be. If it's overruled, that means the objection doesn't count, right? So you can continue on with your line of questioning. So some common objections here is going to be relevancy. So if the opposing attorney is asking a bunch of questions that don't seem to be going anywhere or don't seem to be related to the case at all, you might say, objection, Your Honor, relevancy, right? Well, what's the point of this questioning? You might say leading the witness, right? And so leading questioning or leading questions on direct examination is a common objection. Improper character testimony, so that could be an objection if, say, you're a defense attorney and the prosecution is questioning a witness, and they ask that person, so what kind of guy is he? Is the defendant, would you consider him a nice person? You would say, objection, Your Honor, improper character testimony. Like, this has nothing to do with the case at hand, whether he's a nice guy or not, right? Another big one that pops up, particularly in mock trials, because people have not a lot of experience, probably. I'm gonna go out on a limb and say this is probably for everyone's first time doing a mock trial. So narration. This is when you start giving long-winded answers. You start to go into a narrative and start telling a story instead of answering a question. So you might say, objection, Your Honor, narrative, or objection, narration, and then that's basically means answer the question. Don't tell us a story. Like, find a question in there for this person to answer. Another big one is asked and answered. So objection, asked and answered means you already asked this witness this question, they already answered it. So stop asking them the same question over and over again. It's a waste of time. It can confuse the witness. You might be trying to trip them up. But it's also could be prejudicial to the jury if they keep hearing the same question and answer multiple times. They might give more weight to that question and that answer. So you need to be careful about that. Hearsay, we had already spoken about. That's also another common objection. Objection, hearsay. Opinion testimony. So this, remember, opinion testimony can only be given by an expert witness. So any witness on the stand who's not deemed an expert by the court, by the judge, is not allowed to give their opinion on the case or on the defendant. Another objection would be no personal knowledge, meaning this person doesn't know the answer to that question, right? If they give an answer, it's basically just going to be speculation at this point. So you might hear the opposing attorney ask a question that you know damn well that witness has no idea. They would have no idea what the answer to that is. So if they do provide an answer, it would just be guessing or speculating or making inferences. And that's not what witnesses are there to do. The witnesses are there to act, right? So you might raise an objection, and of course you want to do it before the witness starts to answer. the question and say, objection, Your Honor, no personal knowledge, right? That this person doesn't know the answer to this question. And it would be up to the judge to determine whether they agree with you or not, right? So let's take a look at, I'm pretty sure this is cross-examination, but there might be some objection in here. This video didn't load before, so hopefully it loads now. That's the reason why I'm not sure what it is, because I couldn't see it before. Okay, so these are objections, different objections.
An objection is when one of the lawyers has a complaint about a question that's asked by the other lawyer or about some of the evidence that one of the witnesses is going to give. And some of the common objections that you might hear are when the witness is about to give evidence that's hearsay, or when the question is irrelevant. Or you might hear a lawyer object if a question in direct examination is leading, because in direct examination you can't ask a question that suggests an answer to a witness. Or finally, you might hear a lawyer object if they feel that the other lawyer is badgering the witness, which is probably something you're familiar with from TV, where the lawyer just keeps hammering away at the witness with the same question without giving the witness a chance to answer it, or just keeping because the lawyer doesn't like the answer. So when you have an objection to make, the first thing you want to do is stand up and wait for the judge to recognize that you've stood up. And then once the judge turns to you and gives you an opportunity to speak, you make your objection. And then the other lawyer might respond to the objection and say why they think the question is relevant or why it isn't leading or something like that. And there may be an opportunity for you to respond to that. And the key thing to remember is that all of the exchange should go through the judge. So the two lawyers aren't talking to each other. They're always speaking to the judge. After the judge has ruled on an objection, then the lawyer who made the objection sits down and the examination continues in accordance with the judge's ruling. There's no further opportunity to argue about it. Objections are difficult both for the lawyers and for the judges because it's something that you're doing on the fly, so you really have to respond to the question that's being asked or the evidence that's being given without having much opportunity to think about it. You have to decide whether it's something you're comfortable with or you have a complaint about, and then stand up and object. And the judge has to decide on the fly whether they think it's acceptable, either the question or the evidence is acceptable, and then rule on it. So it's really difficult for everybody involved. The idea is that you'll get a fair bit better at objections the more trials you do, because you'll have more experience and you'll be more used to understanding what types of questions and what type of evidence is acceptable and what isn't.
An individual at the school.
Just one moment, please.
Objection, Your Honor.
And what is the basis for your objection?
The evidence is hearsay.
All right, any response?
Yes, Your Honor. This is basically part of the narrative as to why Donovan Tizzy is a suspect and why he was further sought out to be questioned. And also, the rumors aren't going to be used for the truth of the matter. It's just basically for the narrative as to why he was suspected.
All right, I'm prepared to admit the evidence as part of the narrative to explain the officer's actions and what happened, but not for the truth of the contents.
Okay.
Thank you,
Go
Your
ahead.
Honor.
Thank you.
So, if you couldn't tell by how they were saying about, that was a Canadian court, right? So that explains the attire that they were wearing. But that same process is what happened more or less in a courtroom in the United States, right? So it's the same principle. You are not going to be able to stand, so that's okay. You can just say your objection out loud for the remote mock trial, and I'll ask the other attorney if they would like to comment on the objection that you made. They might offer an explanation, or they might say, okay, withdrawn. Say, okay, yeah, you're right. That was hearsay. Okay, never mind. Sorry. Right? But they might say, no, this is my explanation for it, and then I'll make a ruling and we'll proceed. I'm gonna stop right here and come back. Let's take care of closing statements. Let's get them out of the way. So, and we're back. So, I said let's just take care of the section dealing with closing statements. Just try to keep this all under an hour for this video. So lawsuits are usually won during the course of the trial, not at the conclusion. So lawsuits are won by witnesses and by exhibits, and the manner in which the attorney paces and spaces and handles these witnesses and these exhibits. However, sometimes lawsuits have been lost by fumbling or stumbling and having an incoherent closing argument, or closing statement. So you're not likely to win the trial by having a wonderful closing statement, but you can certainly lose a trial or lose a case by having a bad one, right? So closing statements are important. It's something that you definitely want to get right. So when it comes to their purpose, what's the objective here? Well, it's to provide a clear and persuasive summary of, one, the evidence you presented to prove your case, your side of the case, right? And two, the weaknesses of the other side, or the other side's case. So what we want to do is first outline your summation. So go through a summary. You should not presume that the testimony has stuck in the minds of the jury. So don't say as you heard, right? Just remind them of what they heard. Remind them of what happened, what testimony was present. Also show appreciation to the jury for listening to the presentation of facts and evidence. But don't be too flowery. You don't want to be too ass kissy when it comes to the jury. Just thank them and be polite. Also, you want to review previous representations. So review facts where no discord concerning them makes it possible for you to say the evidence has established facts you said you would prove. So in other words, don't say you did something that you didn't do. Okay. When it comes to issues, the prosecutor should narrow down the issues completely, and the defense should create as many issues as possible so that the jury will tend to feel that the prosecution failed to prove them all, right? So it's kind of it's a reverse strategy. Prosecution wants to narrow it down. These are the important things. Don't get hung up on the details. We have the fingerprint. We have this. We have that. The defense, on the other hand, wants to make as many issues as possible. They don't have this. They don't have that. They don't have this. They don't know where that came from. They don't know what time that happened, right? This is all an attempt to show, look at all the stuff that the prosecution did not prove, right? It's all an attempt to create doubt, reasonable doubt in the jurors' minds. You might also cover the law in as favorable a manner as possible for your case. This is particularly true if you're the prosecution, right? You might say, murder one requires premeditation. We showed that the defendant planned out this murder, right? So you might remind jurors of that. You might look at problems in your opponent's case, in the opposing attorney's case, especially a failure to produce a key witness or to present key evidence. So, where's the murder weapon? Well, they can't find it, right? Or where's the body? They don't have a body. There's no definitive proof that this person's even dead, right? So that would be a big example of failing to produce key evidence. But yeah, sometimes murder trials happen without a body, and they could be successful even without a body. The closing statement should be natural and convincing. When we talk about dramatics, it should be within the range of the attorney's ability to perform them convincingly and effectively. So if you want to start dramatic or say emotional, make sure it's something that you can do effectively and convincingly. People will see right through you if you're trying to fake anger, right? Or if you're trying to fake sadness or indignation or something. But if it's something that you can do, go ahead. The courtroom is the theater, basically, right? It's all a show here. So what should be included in closing statements? Well, thank the judge and the jury for its time and for its attention. Isolate the issues and describe briefly how your presentation resolved those issues. So your presentation meaning the evidence that you presented. Also review the witness's testimony, outline the strengths of your side's witnesses, and also outline the weaknesses of the other side's witnesses. You also want to review the physical evidence and outline the strengths of your evidence, and also outline the weaknesses of the other side's evidence. Also, you want to state the applicable statutes and any cases to show that it supports your side. That's not something you have to worry about for this class. We're not going to be using case law in this mock trial. We also want to remind the judge or the jury of the required burden of proof. So, particularly if you're the defense attorney, you want to really hammer that home, right? It's beyond a reasonable doubt. So you remind the jury of that standard, and how you met it if you're the prosecution, or how the other side felt to meet that burden if you're the defense. Also, don't forget to request the verdict that you desire. So you want to say to the jury, we hope that you will come back with a guilty verdict, or after deliberation, where we ask you to please come back with a not guilty verdict, right? So ask the jury for the verdict that you want. New information cannot be introduced in the closing argument or the closing statement. This is just a summary. This is the conclusion of the trial. So this is not the time to present any new evidence or call any new witnesses, or to even talk about anything that wasn't already mentioned throughout the trial. This is also not a time for objections. So you want to avoid objections during the other side's closing arguments. There are a few exceptions, such as somebody's trying to introduce new testimony or new evidence or new facts that were not previously mentioned, that you could certainly object to. Okay, so we spoke a little bit about the goals here and the objections. When we talk about the different objections that can be used or stated during closing arguments, this is one of them is arguing matters outside the record. So this is kind of common in mock trials. Often the attorney has prepared closing arguments in advance on the basis of what they expected to be presented at trial, but it turns out that some things don't necessarily get presented at trial. So I try to leave closing statements for a separate day, not the same day as the last witness has testified. That way it gives you an opportunity to change your closing statements, because some of the evidence that you expected to be mentioned might not get mentioned. And here you are in your closing statement talking about evidence that was never presented. So this would be an objection that could be raised during your closing statement. Evidence misstated. So attorneys who, again, write up their closing arguments in advance will, again, have to assume that the evidence would come up in a certain way. This is just part of the preparation of creating a closing statement. You have to kind of make some assumptions about how things are going to progress. Problem is that when we actually do the trial, they might not progress the way that you thought they would. So your closing statement now is actually misstating the evidence, and there's some errors in there. So again, be able to change, to amend your closing statement accordingly. That's why it's important to pay attention to all of the testimony, the direct testimony and cross-examination of not just your witnesses, but the other side here. Been through that. Sorry, guys. Sorry, everyone. I missed it. Okay, so appeal to prejudice is another objection. So beware of arguments that may inject prejudice through references to a person's race or religion or ethnicity or anything that might try to inject prejudice into the argument. Another objection is counsel's personal opinion or attack. An attorney may not express their personal opinion on who or what to believe. So it's not up to the defense attorney to say, I don't believe that witness. I don't believe that she's telling the truth, right? It's none of your business. You're just there to ask questions, right? And your witnesses are there to answer those questions. Keep your opinions to yourself. So, you should also not engage in personal attacks against the opposing counsel or witness. So, don't start berating a witness or badgering a witness, or don't lob attacks over to your opposing attorney over there. Also, the golden rule, asking the jurors to put themselves in the place of the prosecution or the defendant, and to do unto them as they would have done unto themselves, is improper, right? So saying to the jury, what would you have done if you were in that same situation? Wouldn't you have done the same thing, right? That's an objection right there. So you should not be posing any type of moral questions to the jury. They're not there to decide morality or ethics. They're there to decide what's true and what's not. They're the triers of facts, right? So don't use that whole what would you do in the same situation type of ploy. That could be an objection. Okay, so let's take a look at a closing statement here.
Members of the jury, it's that time. These were the words the defendant used to murder Nancy Mason. But it wasn't just those words. Every word that he wrote in the Christmas night email that he sent to Frank Norton had only one meaning, only one interpretation, and only one goal: kill Nancy Mason. Let's take a look at those words again. Hey, buddy, it's time to do your thing. She is leaving me for some Bubba. Remember, I need to know for certain the deed has been done. Give me a hand on this, okay? Try as he may, the defendant cannot run from these words. And today, through the presentation of testimony and evidence, we've showed you how these words got their power, how these words transformed the defendant's plan to murder Nancy Mason into action. You see, you learned today that when the defendant and his girlfriend, Miss Mason, started having problems, the defendant started shopping for a solution. The only solution he saw. He started shopping around for someone to kill Nancy Mason. He started with his friend Chuck Seberg, but when Chuck Seberg turned him down, he moved on to someone who he knew would give him a hand on this. And that someone was Frank Norton. Now, you met Frank Norton today, and he told us some things that made us uncomfortable, some things we did not want to hear. And nobody tried to stand up here and tell you that Frank Norton is a nice guy. He's not. But the fact of the matter is, nice guys, those are not the kinds of people that accept $5,000 in exchange for taking a human life. Nice guys are not the kinds of people that the defendant associates with. Members of the jury, make no mistake, Frank Norton is here because the defendant chose him to murder Nancy Mason. The defendant made that choice, not the state. And whether we like him or not, we have to look at the fact that Frank Norton's testimony is the only one that matches up with the physical evidence in this case. Because the defendant's story, well, it just didn't make sense. And when I got a chance to cross-examine the defendant today, we got a little bit more information. See, the defendant wants you to believe that he was worried about Nancy. He wanted her to come home. And he knew all along that she had gone to Austin with her new soulmate. But he didn't tell the police that. Not on January 3rd. Not on January 4th. Not until March 6th, the day he was arrested for her murder, did this defendant say anything to the police about Miss Mason's trip to Austin with her soulmate. Now, does that sound like a man that wants his girlfriend back? Someone who would withhold vital information from the police about her whereabouts? Of course not. The defendant also wants you to believe that he knew all along that Nancy Mason was going to break up with her new soulmate and move back in with him. Another thing, he neglected to mention to the police until March 6th, the day of his arrest. But remember, we showed you the email that Nancy Mason sent to her friends on Christmas night. An email in which she says she's leaving town with her lover, her BFF, her soulmate. Does that sound like a woman who's planning to break up with this guy and go back to her ex-boyfriend? No. Now, maybe Nancy Mason did change her mind in Austin and decide to go back home to the defendant. Maybe she didn't. The truth is, it really doesn't matter. It doesn't matter because you heard the defendant's words in describing that fight he had with Nancy on Christmas night. She needed time. I did not want to give her that time. Well, we know that, don't we? He didn't give her time. Not a few days, barely a few hours. In the defendant's mind, Nancy Mason was a dead woman walking the minute she stepped out of that restaurant. So he went home and he typed his Christmas night kill order that he sent to Frank Norton. And just a few days later, the defendant got a response to this email from Frank Norton. You saw that today, too. It's done. Proof is in your truck. Time to show me the money. The thing that was done, Nancy Mason had disappeared. Her body had been dumped to the depths of Canyon Lake. The proof? You saw that. Here it is. Nancy Mason's severed hand sitting in the back of the defendant's pickup truck, just like he asked. Finally, the money. Here it is. $5,000 from the defendant to Frank Norton. That check was written on January 31st, after Nancy Mason's hand had been placed in the back of his pickup truck, after he sent the email requesting that Nancy Mason be killed. Members of the jury, make no mistake, the defendant paid for what he got: a murder, a missing body, and a hand. Now, in just a moment, Judge Rose is going to instruct you on the law that you must follow in reaching your decision today. And as he'll tell you, the law does not require proof beyond every possible doubt. In life, there are very few times when we know anything beyond every possible doubt, and that's not what the law requires here today. We're required to prove this to you beyond a reasonable doubt. And we've done that. Because, members of the jury, there is simply no other explanation for how perfectly this evidence lines up. And that is why in a few moments, when you go back to deliberate, I'm asking you to return the only verdict that is supported by the law, the only verdict that is supported by your common sense, a verdict that tells that defendant he got exactly what he paid for, a verdict finding him guilty. Because, members of the jury,
Okay,
it's time.
she's really good, right? So, pretty good closing statement there. The next time that we talk, or I might do a video about this, but we'll be meeting and discussing how to prepare the witnesses. We might save this for live type of discussion instead of doing a video for it. So I hope you found these little tutorials helpful, along with the information that I have posted concerning questioning and objections and opening statements and closing statements and rules of evidence. So look forward to actually seeing all of this stuff happen, right? It's exciting. Okay, I'll see you soon.